If I was an assassin and you hired me on a contract to kill somebody, but then you later breached or interfered with that contract in some material way, could I sue you under contract law to enforce the contract or require an obligation on your part to be fulfilled? Welcome. This is the case video overview for the J. Lilly v. Clearspan Fabric Structures case from the state of Oregon in 2020. And so this is a recent case concerning contract law. It's an interesting one in retrospect with respect to the analogy I described earlier about illegality, or at least in some contexts. And admittedly, the example that I just provided is an over-dramatization of the circumstances. This is not a murder contract or a hit-for-hire contract, but it does involve illegality at the federal level, specifically of controlled substances and how we address that. And so that's one of several variables that comes into play with the J. Lilly case and how it's carried out. And as you'll see, there's a number of contract issues that come into play with this case concerning the facts in dispute and how the parties wrestle with those for the purposes of establishing their case and how things pan out in the end. So with that being said, let's go ahead and dive into the material. So at the onset, before we get into the case itself, it's important to discuss what available contract damage remedies there are in different types of cases. And so there's a list of these, and I want to just look at them briefly so that everyone kind of understands what is available to you in the event that you have a contract with someone and you feel that they have dishonored their obligations or failed to meet them. And maybe that's controversial. Maybe there's a dispute over whether or not there was in fact a breach, or maybe there's an undisputed breach. And the question just becomes, what is the appropriate remedy? And so the point here is that there are a number of different avenues you can pursue as a plaintiff to a contract dispute if you feel you've been wronged. And so we're going to look at just what some of those are. And we've discussed these in the past in different videos in the context of, for example, negligence claims, and some of the damage categories are the same in those contexts. So we're going to be looking at different examples and how they apply. But in this particular perspective, it's the context of a contract dispute. So compensatory damages, as we've discussed previously, these are the types of damages, as the root word would imply, that are intended to compensate the victim, right? They're aimed at making that person whole again. And in some cases, you have just one victim. That would be normally the non-breaching party in a contract dispute. And in some cases, you have situations that are quite complex where you have both parties sort of countersuing each other, or even more than two parties that are suing across different parts of an agreement for the purposes of trying to establish what happened, what should have happened, and what the proper remedies are to fix that. So compensatory damages are, again, if there's a breach of contract, it's aimed at making the individual whole again. So an oversimplified example would be that if I agree to mow your lawn for $20 and I complete the mowing of your lawn to, specs and to your satisfaction, but you refuse to pay me the $20 that we had agreed upon, and assuming, all other facts about the enforceability of the contract and not bringing up any issues as to whether or not it's valid, the compensatory damages for me would be the $20 that you owe me, right? And we could even get into issues related to things like interest, how long the $20 has been an unpaid balance and gone outstanding, and what that means in terms of total compensation. Has it cost me any other work, reputational damages? There's a lot of factors there. But that's the main idea behind compensatory damages, is to make the parties whole again. Now, incidental damages, when we talk about incidental damages, we're talking about damages that are intended to cover losses, right? That are incidental, not necessarily that are the primary focus of the subject matter of the contract or the transaction, but that they're incidental to it. They're tangential to it, but they're related. So if I have to, cover my costs in another way because you're unavailable to support your end of an agreement, then that could be, a related incidental damage. So, an example would be if I agree to buy a car from you and you agree to sell me the car, but then, on the day that we're set to exchange car for money, you change your mind, or you try to hold out on me, or you want to change the terms, and you breach the commitment that you've made to agree to sell me your car. right? And so as a result of that, I then have to go and find alternate transportation to accomplish, whatever my goals are. Maybe it was a work truck or something and I needed it for business. And now because I can't proceed with the deal as we had agreed upon for your vehicle, I've got to go and buy that vehicle somewhere else. And maybe that purchase is going to cost me more money, right? Significantly more than what it would have cost me if we had just proceeded with the original commitment that we had made for the purchase of your car. Well, the difference between, what I would have paid you for your car and the difference of what I would have paid somebody else might be considered an incidental damage, right? I had to cover the costs of my loss. Otherwise, if I didn't have the vehicle, maybe I couldn't get to work. I couldn't do my jobs. I couldn't honor other commitments. So I had to move forward, but there were costs to me incidental to that, right? Which is what we're talking about here. Consequential damages are the focus of the J. Lilly case, which is what we're going to discuss here. And it's specifically referenced in the contractual document in question. But the issue here is this is the kind of thing that relates to the foreseeable fallout of a breach of contract. So the question related to, an example that we used just a moment ago, which was with respect to me purchasing, say a work truck from you so that I could engage in business. Let's say that I'm I'm a pizza delivery driver, right? And I need the vehicle that I'm buying from you to be able to run my pizza business and deliver my pizzas. And without your vehicle, I can't run my business. And so a consequential damage of not being able to purchase the vehicle and not honoring the commitment that you had to sell me your vehicle would be that if I can't find an alternate means of moving forward, I might suffer damage in the form of lost revenue for pizzas, right? I can't sell pizzas. I can't deliver pizzas. My business is now being affected by this. And so that could be considered potentially a consequential damage. Again, assuming that I don't have any a duty to mitigate and an alternative means of mitigating, right? A way that I could, again, just, go buy another car somewhere else. If I could do that, then it may be incumbent upon me to do so. But assuming I can't because, let's say you have a very specific vehicle that I need and I can't find it elsewhere, or whatever the case may be, if it's not practicable for me to do so, then there may be a foreseeable fallout in the sense of, hey, you have to know that in addition to not selling me your vehicle, this is going to affect all of these other things down the chain for me, which may result in additional ramifications for you in terms of, again, that fallout that comes from it. But the thing that's important to understand about consequential damages is that the foreseeability element is key. It's absolutely critical to what we're talking about in this case and in every other case that involves the damages. The restatement of contracts, sort of the guiding recommendations and the document that informs contract law and precedents on this issue, speaks to this issue not as foreseeable, but it uses the word contemplative, right? The ability of the other parties that could potentially breach an agreement to have contemplated at the onset, right? When they made that agreement with you, whether it was to sell me a car or to, fix my house or whatever it is, the ability of that party at the onset to have contemplated that there could be these fallout consequences of a breach, right? To know or have reason to know at the onset that, hey, if you breach, you do understand that this is pivotal to all these other things and that it could have a domino effect, right? That could result in ramifications that extend beyond just, you selling me a car. This is not me buying a car for leisure purposes so that I can drive it to the beach and hang out. This is me buying a work vehicle because I need it for my business. If you know that, if you have that information at the onset, then there may be an inference that you had the foreseeability to know that, again, breaching that contract would result in fallout beyond just, again, the sale of the vehicle in this question or whatever the case may be. And as we discuss in J. Lilly, this is going to concern the foreseeability of the manufacturer of the greenhouse as to the nature of the scope of revenues to be generated from the greenhouse and the inability of J. Lilly to do that in the absence of a working greenhouse. So that's key here. Some others that are, just to be comprehensive here, not necessarily pivotal to the J. Lilly case, but just to understand. Nominal damages are, you can think of these as symbolic damages. They generally have little or no value, but they represent, nonetheless a victory in a case, if only on principle. And they deal with things related to, where there's circumstances of either little or no loss due to, little or no actual consequences, actual damages resulting from the breach. So this is why the damages themselves are usually little or no value. It might be $1 or $5. So an example would be, going back to our work vehicle sale example. You agree to sell me a work truck. I agree to buy a work truck. I come to pick it up, and you say, I'm not going to sell this to you. I changed my mind. I'm breaching our contract. And let's just assume again, we have it in writing and we've dotted all the I's and crossed the T's, so it's enforceable, but you are nonetheless refusing to proceed with the transaction. So in which case, I go online and I'm desperately looking for a truck, and lo and behold, I find the perfect truck. It's the same truck that you have. It's exactly what I need. And let's say, for just added, context, that it's $100 cheaper than what I would have had to pay you for your truck. So I go and pick up said truck, from some alternate seller, and I've lost nothing, right? I may have lost a half an hour of my time, for the sake of having to do additional research and find another deal, but I didn't lose anything because I found the truck and I actually found it cheaper than I would have had to pay you. So in those cases, I may have a contract breach case that is enforceable in principle, but I may not be able to show damages, right? Because I really can't show that I was hurt by your refusal to proceed with the contract. If anything, I gained a little bit, right? So if I take this to court and proceed with everything, I may end up with a symbolic victory. The court may sort of rubber stamp and say, yes, you are right in this case, but there's nothing really there to award because there's no harm done. In fact, it's just the opposite, right? So there may be a nominal award of some, $1, $2, $5 amount, just to reflect the actual victory, but it doesn't amount to anything substantial because there's no receipts for any harm done in that sense. Punitive damages, and we've talked about this as well in the context of negligence and other types of disputes, but these are the kinds of damages that are available usually for the purposes of trying to punish a defendant in a case for conduct that is truly egregious. And when we talk about egregiousness in this context, we're usually talking about intentional and malicious conduct, or at least malicious conduct that is reckless enough to rise to the level of being egregious. That is to say, beyond the scope of ordinary lack of care or disregard, but something that is truly wanton, in that respect. So you may have punitive damages, and again, that root word being to punish, right, for conduct that is extreme in nature, and that as a matter of public policy should be met with retributive justice in that respect. And finally, we come to one last component here, which is, potentially an element in some cases, depending on the circumstances. And this is something called specific performance. And so what specific performance directly relates to essentially is, do you have the option to force someone to commit and fulfill and execute their obligations under a contract, right? And then this ultimately depends on the circumstances. And if you notice, impliedly with this idea of forcing someone to perform an act or engage in a service, or whatever it is that they're being forced under penalty of legal consequence of arrest and criminal fines to perform conduct, is 13th Amendment implications over slavery, right? I mean, we don't even do this for incarcerated people, right? For the most part, slavery is outlawed. We cannot force people to do things they don't want to do. We may force them to pay for damages due to their failure to meet their commitments, but it's quite another thing to say you're going to force somebody to perform. Now, it's not to say that it's illegal or that we never do it. We do it sometimes when it's appropriate, when there are no other appropriate remedies to right or wrong other than to force the individual that has breached a contract to engage in whatever it is that they were supposed to do in the first place. So going back to the, me buying a work truck from you for pizza deliveries or what have you, there may be an available remedy. If I can show that I need the truck that you own, that no other truck will do because it's that specific truck, that truck was driven by Marilyn Monroe and some movie, generation ago, and it's, it's famous for that ride, and I have to have that one with that VIN number because it means, whatever the case is, it's not a matter of just finding another one off at any other dealership, right? I've got to have that vehicle. It's essential, and it's not really requiring you to perform a service. It's just requiring you to surrender the truck and take the money that we had agreed upon for it. That's the kind of circumstance where specific performance may conceivably be appropriate. Now, again, the example that I just described is kind of outlandish. You're not likely to find those specific circumstances very often, but you will find it in the case where, and this is where it becomes complex. Imagine, and there are famous historical cases built around this. Imagine that I retain you for the purposes of painting a portrait of me, right? Because you are a famous artist and I want you to paint my likeness. I like the work that you do and I want you to do that. Okay. And so we agree and I pay you money for it. And before you're set out to begin, you say, no, I can't, or I won't. I've changed my mind, what have you. I'm not going to paint you. Okay, well, then I take you to court and sue you. But really, it's not a matter. This is a unique situation of artistic product where I can't just go to the next artist and be like, well, this will be just as good, right? Because artist work is unique and there's nuance to it and there's special taste involved. And so, but on the other hand, forcing you to paint me would be tantamount to indentured servitude, right? It would be forced labor, which is, as a matter of public policy, something that we have, rejected. And for good reason. So there's a lot of implications when it comes to specific performance, and needless to say that it is something that is used rarely, but it's just important to understand that this is the full spectrum of things that are potentially available in the event that there is a contract and a breach thereof that requires some kind of remedy. And so these are the things, and specifically, again, we're going to be talking about consequential damages in the context of J. Lilly, but I want everyone listening to this to understand that full context as we move forward. So this case, as we've alluded to a little bit already, involves a grower of cannabis in the state of Oregon and a producer, manufacturer, leaseholder of greenhouses that can be used for various purposes, not the least of which is to grow cannabis. And so the contract dispute is between J. Lilly, the grower, and Clearspan, which is the greenhouse manufacturer, and in this particular case, a leaseholder. And so it's a rather complex arrangement of payments and options to buy and so on. And so we're going to go through some of the basic facts here, just so you have the necessary pretext and context, the framework that is necessary to understand why this cause of action was brought by J. Lilly against Clearspan, and why ultimately the court found in favor of one party over the other for the evidence that was presented in court. So under the agreement that J. Lilly had with Clearspan for the purposes of this greenhouse, there was an arrangement that they were leasing the greenhouse for 16 months for an amount total of $300,000. That was the arrangement of the initial term here. But the key here is that there was an option to purchase for just $100 at the end of the lease, right? So this really amounts to almost like a mortgage agreement, although it wasn't structured that way, right? It was structured in such a way that it was a lease from Clearspan with an option to buy for just $100, which against the context of a $300,000 product seems, it's nominal, right? As we discussed earlier. And so really what we're amounting to is that, okay, 16 months of usage by J. Lilly, and at the end of that, they own the thing, right? That's as long as they make the payments and they agree to pay that last $100, then it becomes theirs, right? So that's the arrangement that they have with Clearspan. It's almost like a financing agreement, right? Just a way to hold the tab open and to keep a note for the payments that J. Lilly would make against it. And Lilly was solely responsible for equipment and assembly, right? So this was dictated in the contract and stipulated that, there were different aspects of the contract in terms of who was obligated to do what, but Lilly was stipulated as having been responsible for equipment and assembly. The contract had a clause that made it the entire lease agreement, right? So this is what we typically refer to as an integration or a complete integration clause, which basically says, look, and this is used in contract law a lot, is intended to make sure that neither party or no parties, if there are more than two, can bring into a particular suit a claim that, hey, this is here's a lease agreement, but by the way, there's also this other document that we had, or there's an email that we exchanged, or there was a verbal conversation, or what have you. They can't bring anything in extraneous to say that this helps to clarify or modify the terms of the agreement. So we put in our contract something called a complete integration clause, which basically just says, look, it speaks to what we commonly refer to as the four corners, right? The four corners of the piece of paper that you're looking at, or pieces of paper, assuming it's multiple pages. This is the boundary of this contract, right? This is everything that relates to this contract is in here, and no parole evidence shall be subsequently allowed, meaning you can't come later and say, oh, we forgot this piece because we talked about it over an email, but it didn't go in the agreement. We just must have left it out by innocent omission. It wasn't on purpose. But here where it says I'm supposed to pay you $300,000, it actually says I'm supposed to pay that over 24 months and not 16 months. That kind of thing would commonly happen in the absence of a complete integration clause that precludes it, right? Where this clause in the contract says you can't do this, right? You can't bring this in. This is the entire contract. Anything outside of this is invalidated by this clause, because anything that the parties intended to be in here is already in here on this document. So that's what that's intended to do. However, with respect to J. Lilly and the Clearspan case, any written agreement to which the lessor and the lessee may be a party concerning the design and or construction of the equipment shall be unaffected hereby and shall continue in full force and effect. Right. So this is key, because the ultimate dispute concerns the quality of the greenhouse and repairs that were made there too or not made. And so the lease agreement says, this is the entire agreement. However, it also says in a somewhat contradictory way, or self-contradictory way, that any other agreement between these two parties, meaning J. Lilly and Clearspan, may have regarding the design and construction of the greenhouse stands, right, and is otherwise unaffected, right? So it isn't changed by the lease agreement. It doesn't, is it invalidated by the lease agreement? It's just a separate standing agreement. But the question is, if there's conflicts between the two, or sort of parallel language speaking to different aspects of obligations, how do you reconcile those, especially when you have a complete integration clause, right? So that's one of the issues that arises here. So the construction agreement, right? We have a lease agreement and we have a construction agreement. The construction agreement between J. Lilly and Clearspan said that Clearspan agreed to install the greenhouse for about $278,000, right? $278,000, with $75,000 due, so roughly 25% before shipping. And the balance is due in consecutive monthly lease payments, which shall be due and payable by Lilly not later than 30 days after Clearspan's issuance of an invoice. So basically net 30 billing terms, right? And this is what brings us to the, roughly the $300,000 mark for the purchase of the greenhouse assembly and the facility that's provided. So under the construction agreement, section 2.2 of this contract, this is where, when you're dealing with contract law, you get into the nitty gritty of what is said, what language is used, and how. Everything purchased by Lilly from Clearspan shall be covered exclusively by the warranty attached hereto, right? So there's a warranty reference in the construction agreement that says everything purchased, which sounds comprehensive, right? That would mean everything, all right? There's no exceptions there. There's no unambiguous language. Shall be covered exclusively by the warranty attached hereto. So it's referring to an addendum to the contract or an appendix to the contract, which should be, in theory, a warranty, right? Now, the construction contract had only two exhibits, right? So there was only two documents appended to it. Exhibit A, which included a construction form and some design documents, right? So that's one piece. And Exhibit C, which includes documents entitled Clearspan Fabric Structures Installation Warranty and Manufacturer's Product Warranty for a Class 4 structure, right? So in theory, if it was to be one or the others, it's probably Exhibit C here, because these at least specifically represent what by their titles are impliedly warranties, right? So the lost profits element, Lilly complained during the course of ownership and operation after the installation of the greenhouse of multiple defects with respect to the greenhouse, the quality of construction and materials, and so on and so forth. Clearspan did do some repair work, so they had fixed at least one issue related to complaints, but they also ignored others, right? So there's kind of some mixed conduct here on the other side. It doesn't seem like they were completely responsive to the concerns about quality related to J. Lilly's, complaints. The ignored defects, the ones that were not fixed by Clearspan, were severe enough in terms of quality and what they meant with respect to the integrity of the facility, that they prevented Lilly growing cannabis, that it actually was enough to stop the ability for them to harvest, to cultivate and to harvest the cannabis that they were growing. And according to them, they had lost roughly $5 million, about $5.5 million actually in profits. So this is based on, again, Lilly's speculation, and as we'll come to find, it's probably not a good one, or at least a sound one, right? So we're going to talk about where they arrive at that number or how, and it's not a great justification, but that's the number they arrive at, right? The construction contract had stated, again, this is not the lease agreement, the construction agreement, that Lilly agreed to waive all consequential damages, right? There's the first use of that term in this case, consequential damages, right? And Clearspan also agreed to waive all consequential damages except for the lost profits on its anticipated sale of construction products and services, right? So it appears to be a bilateral clause in the construction agreement that says both parties agree to waive consequential damages. So as you may be sort of anticipating with this case, what we're getting to, insofar as its claim from Lilly, is that, look, your greenhouse wasn't up to snuff, in our opinion, right? It didn't meet standards that we expected. It didn't perform. And as a result of that, not only did we lose the value of a greenhouse that we're intending to pay $300,000 for, because that's one element of damage recovery, right? Is that I'm supposed to pay $300,000. That was the agreed upon price. And it should be for a greenhouse that meets certain standards or expectations that were set about at the time that we made this agreement, right? That it should be worth the $300,000 I'm paying for it. And there's a value in that. And if it doesn't hold that value, that I should be expected to be able to recover that in suit if need be. But the other element of it, and the more pivotal element here, and obviously the more costly element where the dollars really come into play, is that Lilly says, look, as a result of your stupid greenhouse that didn't perform as it was supposed to, we've lost more than $5 million in marijuana sales, right? Or in cannabis sales. And because of that, you owe us not just for your greenhouse that needs to be fixed and or replaced as necessary because it's not meeting expectations or not doing what you said it would do, but also you need to pay us for all the marijuana that we weren't able to grow and produce and sell because your greenhouse failed on us, right? And that's the pivotal component of this contract dispute. So as we look to the lawsuit, Lilly is obviously suing Clearspan here, and they are asking for several things. One is which is for the contract to be rescinded and the monies to be returned that were paid on the contract. Okay, so that's with respect to the purchase of the greenhouse and the installation and so on and so forth. They're also looking for the cost to replace the greenhouse. Or at least the reduction in value caused by the defects, right? So either give me the money that I need to buy a greenhouse that actually works and accomplishes what we set out to accomplish with this, or give me the value in terms of the difference in value that these defects have caused to the greenhouse that I actually purchased, right? So in other words, I expected to pay $300,000 for a greenhouse that was supposed to work and meet the needs that I had for this application. It didn't. So the greenhouse that I now have is worth something less than that, right? And we can argue about what that's supposed to be, but I want the difference, right? That's essentially what Lilly is saying, is that, we want the difference between what we were supposed to get and what we actually got, which sounds logical, at least in principle. And then finally, they want the $5.4 million in profits for marijuana that they weren't able to grow because they weren't able to produce, the cannabis that they had intended to produce under the greenhouse because it didn't work as intended. So Clearspan comes back as a defendant and actually countersues for breach of the lease, which is not at all uncommon in contract cases, right? Because usually there's two parties that disagree and they're pointing fingers about who did what, said what, who was supposed to do what and didn't, right? So this is very common that you have countersuits. And so Clearspan countersues and says, no, you're being unfairly enriched by taking advantage of a greenhouse that you're not intending to pay for, and we're also looking at other causes of action to recover or repossess our greenhouse because you're not making payments against it, and this was part of our agreement. So they're alleging that Lilly's breaching the agreement by refusing to continue to make the payments and proceed with the payment plan as it was originally laid out, right? So the issues related to the legality of these actions. Clearspan moved for summary judgment on the lost profits issue. In other words, when we move for summary judgment, also known as an MSJ in the legal world, we're basically saying we need to, they're asking the court to throw this claim out by virtue of whatever legal argument says that it's not actionable, that it can't move forward. It could be a 12b6 claim, for example, that says there's no claim upon which relief can be granted here, or it's not legally sufficient. Whatever the argument is, they're asking the court to throw this part out essentially. So on the lost profits issue, they're stating that, number one, contractually, they were waived by the consequential damages waiver agreed to by Lilly. So they're saying specifically in the contract, it says that both parties agreed to waive consequential damages, regardless of what would happen in the future related to breaches and so on and so forth, that was stipulated to. That the lost profits are too speculative. So they're arguing that the calculation that the party, Lilly, is using to establish that they're owed $5.4 million is not sound, right? And we're going to look at in just a moment whether or not it is, right? And in addition, and this is where we get back to the very beginning of our video with respect to illegality, the court sua sponte, which basically just means on its own, unprompted by either party, questioned the issue of whether it could even enforce lost profits, assuming they were valid, right? Assuming they overcome the claims of foul play by Clearspan, and that they resolved all those issues. Could they even enforce this lost profits claim? Because marijuana or cannabis is still illegal under federal law, right? So this brings up an issue related to sort of the political movement taking place in our country presently around controlled substances, most noteworthy of which is the push to legalize marijuana. Currently, it's something like half of states have legalized marijuana laws. But technically speaking, marijuana has been and still is and will continue to be for the foreseeable future illegal under federal law, which means that as a matter of legal standing, the state laws are invalidated by virtue of the supremacy clause because they conflict, so that the state laws that permit the growing and sale of cannabis or marijuana products are invalidated by the supremacy clause, because where there is a conflict between federal and state law, federal law controls. But here's the thing. In order for that to be any kind of issue at all, the federal government must choose to prosecute, right? They must choose to move forward and pursue these legal issues. And this started, going all the way back to, at the earliest movements of this were the 2000s during the Bush administration, that it saw a lot of traction under the, more progressive agenda of the Obama administration. And ever since then, it has just continued to grow. And that is to say that the states have taken it upon themselves to push these issues as a matter of state freedoms in the states that choose to legalize these products. And the federal agencies responsible for the oversight and regulation of controlled substances, specifically the ATF, FDA and the ATF, insofar as it concerns illicit substances, but alcohol, tobacco, firearms has a large role to play. And the Department of Justice, right, in general, that oversees federal oversight on regulations of everything that happens in our country, can choose to decline to prosecute or decline to pursue these issues. And that's essentially what has happened, is that the federal government has not changed the law, right? We have yet to see Congress enact a major change to the Controlled Substances Act and the categorization or the taxonomy of substances. So marijuana is still listed as a substance that is illegal under federal law, not usable for any purpose, right? But the federal government has essentially said, let's see how this plays out in the states. That's essentially the idea, right? Is that okay, there are concerns on both sides. Those who are pro marijuana say that this is a restriction, an unreasonable restriction on personal rights to do as we please, especially insofar as it comes to things like medical arguments about the use of cannabis and its proven benefits for things like people undergoing chemo treatment and in oncology situations and so on and so forth. But then there's also the recreational side, right, where some people just say, hey, we should be able to use marijuana because it's fun and it doesn't hurt anybody any more than any other legal substance, like say cigarettes or alcohol, and so it shouldn't be impermissible to do so. And so that has been the claim on one side. The other claim, on the opposite side has been that, marijuana is this very harmful substance and that it needs to be, needs to remain prohibited for those reasons. And so the federal government has said, look, let's give this an opportunity to play out and see what happens in the states that legalize it. And so they have been essentially just holding back the floodgates of challenge to the state laws to see how things move forward in terms of the societal implications of legalizing marijuana. And so it's been a conscious restraint, but nonetheless the reality remains that it is still illegal under federal law to grow or sell cannabis, regardless of where you are. This is in Oregon, where this case is taking place, but it could be any state. It wouldn't matter. If it's within the boundaries of the United States, it's still a federal law. And this is happening in federal court in diversity jurisdictions. So the federal court is asking itself, can we even entertain a contract issue for enforcement of a contract that involves the production of an illegal that it essentially involves something criminal under federal law? Right. And so this is a very interesting question as we move forward. So the consequential damages waiver question, right, in the contract, how does this relate to what we're talking about and what does it mean for the contract? So first, the two contracts, meaning the lease agreement and the construction agreement, are separate and they must be analyzed separately, right? So this is articulated under the analysis of this situation. They each had their own, what I mentioned earlier, the complete integration or the integrated agreement clause. That clause that says this is the whole document and there's nothing else to it, right? You're not going to bring anything else extraneous that helps to clarify or change or redefine or modify or reconstrue anything in this document. It is what it is. This is the whole thing, right? But yet they're inextricably linked, right? Because you have a construction contract and a lease agreement for the same facility on the same property and the same parties, right? They're interdependent in some ways. And so how do you then begin to analyze them and interpret them in the context of the fact that they're intended to be separate and not to rely on each other, but yet inherently they do, right? So secondly, there's an issue as to whether the Uniform Commercial Code, right, or the UCC waiver provisions should be applied. In other words, what does that mean within the context of the Uniform Commercial Code that governs transactions in contract between businesses for commercial purposes, and what relevance does that have to the overall context of these claims? So the UCC, first of all, applies only to contracts for the sale of goods, right? So that's going to be key here, because whether or not this greenhouse can be constituted goods for the sake of and sale is questionable. And as you can see here, the lease agreement concerning the greenhouse is certainly not for the sale of goods because it's a lease agreement, right? So that, right off the bat, it makes that suspect and probably not workable insofar as UCC application is concerned. Construction, on the other hand, because that's the other agreement, includes some sales of goods, but on the whole, construction contracts are generally not considered contracts for the sale of goods because they're a combination, when you think about it, for goods and services, right? So you have this combination of, if you have somebody, a general contractor, say, build you a house, you have a contract there that entails, yes, there's goods, there's going to be lumber and plumbing materials and masonry and concrete and sheetrock and all kinds of stuff. And those, if you were just buying them outright, could be considered goods. But on the other hand, you also have the service that those contractors are providing to you in constructing whatever it is that you're building. So it's this amalgam contract, and generally speaking, those construction contracts are not construed as goods under federal law, or at least under the UCC application in that sense. So the court acknowledged that it can still look to the Uniform Commercial Code for guidance in this case and to different case precedents that may have dealt with Uniform Commercial Code cases in the past, insofar as it may be relevant to the circumstances here for help sort of filling in the blanks. But the UCC does not control in this case, right? Because we don't have enough of a tie to the traditional purpose of the UCC, meaning, again, the sale of goods, for the UCC to be an appropriate authority on this subject, right? So that's ultimately where we end up. So getting to the elements for enforceability of the contract, the limitations on liability provisions of a contract, right? In other words, if you're going to have a limited liability component that specifically limits, the parties' obligations or remedies available, then there needs to be at least one of these elements here. So it has to be bargained for, or was called to the other party's attention in some material way, or is conspicuous. So this gets down to the very nitty-gritty nuanced elements of what does it look like in the context of the document, right? Literally, when we hold up the page and we read it, how obvious is this limitation on liability in such a way that it should have been noticed or not, right? And so this becomes really, really subjective in a certain way, because one question would be how big is the type, right? 12 point, 14 point. Is it underlined? Is it bolded? Is it italicized? Is it separated in some way that makes it stand out? So it becomes a very difficult tightrope act to perform for a court in interpreting what is and is not conspicuous enough to establish this requirement, right? So bargain for in this context means that it formed an element of the negotiations in the sense that it was a component to the discussions that took place preceding the signing of the written agreement, right? That it was actually talked about and that there's some evidence of that. In this case, there was no evidence that happened, right? That there was some specific conversation about the component of the limited liability, that J. Lilly said, I want to be available, I want to have consequential damages available as a remedy. And then Clearspan said no, and they hashed it over, and then they agreed on no. None of that happened insofar as the record is concerned in this particular case. There's also no evidence that the provision was specifically called to Lilly's attention, right? So nothing to point out that anybody emphasized this to them on either side, right? That it would have been brought out, and specifically insofar as we're talking about Clearspan's role, right? No one said, hey, just so you know, this is how we've authored this, and it specifically leaves out this remedy for you. So at the end of the day, the enforceability will depend on ultimately, this element of conspicuousness, right? That's the third potential prong, which if you can satisfy it, will get you there, right? So a term is conspicuous if it is written in a manner as defined again by case precedent and looking at the restatement of contracts and past history. If a reasonable person against which it's supposed to operate ought to have noticed it, right? So if a party to the contract should have seen it, should have have noticed that it, what it said and how it would have affected them, then it can be construed as conspicuous. But this is where things become really nebulous in the law, right? Because again, the definition of what that means and how it's interpreted can be difficult to wrestle with. So the plaintiff here, Lilly, argued an oral argument that the consequential damages waiver is inconspicuous because it's just buried in a 45-page contract, right? As they typically are. I mean, this is a commercial lease agreement. It's not at all uncommon for these agreements to be many dozens of pages long, depending on how much boilerplate they have. And so Lilly here is arguing that, hey, this is not something that stood out to us. Why would it have? This is a 50-page agreement, and it's just in some inconspicuous place, right? The very definition here, it is not conspicuous. It's just buried in everything else, and would not have been noticeable to us. But the court here held that it was conspicuous, right? Certainly in the key construction contract, which is the element that is most important here, not the lease agreement, right? So the agreement was just over 7 pages. That's so the lease agreement was 45, but the construction agreement was only 7, right? So we've now significantly shortened the scope of what we're looking at here. The article titles appear in bold, centered, capitalized letters, right? So the court noted the contrast or the way that the titles themselves are emphasized. Article 7 in which this particular clause is found had the heading in all caps, insurance to protect the project and waiver of subrogation, right, related to claims, right? So that's a pretty obvious standout. And then the consequential damages waiver in section 7.4 is a numbered paragraph separated from surrounding numbered paragraphs by spaces. So it's kind of, in its own little section of the page. And it begins with the heading mutual waiver of consequential damages, which is printed in bold typeface, right? So that in and of itself is bolded under the bolded, centered, capitalized letters for the title heading, right? So there's a prominence to it, right, in the agreement itself, which makes it more than just this is buried in the boilerplate. The waiver follows that heading in plain typeface that is the same size as the other numbered paragraphs of the contract. Right. So there's a consistency there with respect to that. So looking at the analysis of the conspicuousness argument, it appears in a briefer contract than the lease agreement, because again, we were talking about a 45-page contract, which would have been a bit more, of a larger context to look at everything in. But this is just a 7-page contract, and it's positioned and printed in a size and typeface that a reasonable person should have noticed. This is what the court opined on the issue of being conspicuous. Provisions in the past have been held to be conspicuous, looking at case precedents and the history of construing these kinds of things, when it was not hidden in small print somewhere within a lengthy written agreement, was located squarely in the middle of a 1-page contract of sale, and was printed in boldface, right? So these are some examples of things that would help to substantiate a finding that a particular clause or a component of an agreement was quote unquote conspicuous. Right, or set off from the surrounding text, right, is another way of looking at it, slightly separated from the paragraphs above and below it, and led by a caption in capitalized letters, as was the case here with the Lilly contract with Clearspan. So therefore, we find that the provision is conspicuous, right? So we satisfy that component. So Lilly can't say that it wasn't fair because they didn't know about it, right? That was the major claim here, was that, this can't be enforced because it was buried in such a way that it wouldn't have been fair to hold us accountable to it. And the court says, no, it's fair enough that it was obvious. You should have read this and you should have noticed it. Because what happens is, what was most likely the case here in all reality is that no one read any of the fine print, including the fine print that happened to be bold and typefaced and, separated in that portion of the document. So getting to the unconscionability, right? The idea that this would just be unfair as a matter of public policy to hold us, to hold our feet to this. This is the idea that the formation of the contract and the circumstances that surround it are unfair in context, right? So, whether or not there's an unequal balance of power between the parties that, results in coercion, whether, implied or explicit. And so this leads to the analysis of whether or not the entirety of the negotiations leading to the contract and the signing of the agreement was conscionable, fair in its circumstances, would lead to something that both parties should fairly be held accountable for, right? So this applies where there is perhaps surprise or oppression, during formation, where one side is forcing its will on the other. An example of this kind of thing, that not necessarily to say that these are illegal, but some, an example that will give you context to understand where there can be a significant difference in power across the parties, would be the situation where, and I use this in my classes, lectures at different times. Everyone listening to this video probably has a cell phone. So you probably have a cell phone contract with some subscriber. It could be Verizon or T-Mobile or what have you, but you have a contract, right, for the use of your cell phone and the use of their network and the, services that they're supposed to provide you with, and so on and so forth. But if you went to your local Verizon store or your T-Mobile store or what have you, and you said, you bring a copy of it with you and you mark it all up and you say, I don't like this term, I want to take that out, I want to change the verbing of, the wordage with respect to this sentence, and, I want to change, let's say, the disputes clause to stipulate the venue as my hometown because I don't want to have to litigate against you somewhere else. Oh, and I don't like this arbitration clause because I don't think that's fair, and so on and so forth. So you run into this situation where, you're doing what any normal person to a contract would do, which would be happy to negotiate, but you're negotiating with some huge corporation that is not up for that, particularly when it comes to, the volume of sales that they have um, with their customers, and the amount of work that would be required if every contract had to be individually customized and negotiated with subscribers. So the companies naturally just say, no, this is a take it or leave it, one size fits all. Now, it doesn't necessarily mean there's coercion, because there's plenty of other options for you. If you don't like Verizon, you can go to T-Mobile. If you don't like T-Mobile, you can go to Sprint or what have you. But at the end of the day, they're not going to haggle with you. They're going to provide the form. They're going to write it for you. They're going to tell you exactly what it's going to say in all of its material forms. And there's going to be no negotiation about, what language is used and where. So, in some sense, you could describe that as a kind of coercion or oppression, or what we would commonly refer to as an adhesion contract. But again, because you're not being forced to take that service under penalty of some major consequence, right? Again, you usually can just switch providers fairly easily. There's no real argument that someone's twisting your arm into it, other than the fact that they're not being negotiable, which at the end of the day they have a right not to be. And anybody that is purporting to enter into a contract with anybody else could potentially argue that, I'm not going to be at all flexible on the terms. This is what it is, exactly as it's written. If you don't like it, then there's no deal. And as long as you're clear about that at the onset, and there's no deception or surprise about it, then, it's probably okay. But what Jay Lilly is arguing about here is that there was, some element of that was unfair on balance. So oppression exists when there is an inequality of bargaining power that results in a party having no real opportunity to negotiate the terms of the contract, and the absence of meaningful choice, right? So here in this respect, again, this kind of sounds like the cell phone example that I just used, but what Jay Lilly is arguing here is that, we were kind of arm twisted into this because there weren't really many alternatives in that way, and we didn't really have any bargaining power to this. So everything that about this contract was forced down our throats in a way that was unfair. Surprise, on the other hand, occurs when terms are hidden from the parties seeking to avoid their enforcement, such as when the terms are printed in fine print or ambiguous. Again, so this kind of gets back to the conspicuousness of particular terms and whether or not they were, right? And in this case, we've pretty much established that they are, or that they were found to be. So that much has been resolved. But there's a general claim of unconscionability here that is pending. So in this case, Lilly produced, according to the court, no evidence to create a question of the fact that the parties were of unequal bargaining power. Plaintiff had a lack of meaningful choice, or that the consequential damages waiver was hidden in a manner that caused surprise. So the court looked at this and they said, no, we don't see any reason here for you to suggest that you didn't have the right to bargain, or that you didn't have an opportunity to haggle with Clearspan about what you wanted and how you wanted it. There was just no evidence of coercion here, and no evidence of something being hidden from you in an unfair way. So the contract was not procedurally unconscionable. Now, getting to substantive unconscionability, this applies when the terms are one-sided, and this can be a little bit ambiguous, right? When you think about it, it's like how exactly are we clearly parsing the difference between procedural unconscionability and substantive unconscionability? And sometimes there are unclear boundaries between the two, right? It's a little bit of a gray area, right? But really here we're talking about the material terms of obligations and duties and executions of the contract itself. This applies when the substantive terms are one-sided. Again, the ultimate issue is whether the terms contravene the public interest or public policy, right? So would enforcing this contract be contrary to what we hold as virtues of, a just and fair society? Was it so unconscionable in terms of what one person had to do for another that it was, coercive or unfair to shock the conscience in such a way? This ultimately can only be analyzed on a case-by-case basis, given the bargaining power, which we talked about earlier, and the circumstances of the obligations. In order to find something like substantive unconscionability, you have to have provisions that are greatly favoring one party over the other, specifically the one that's alleged to have greater bargaining power. In this way, some of the same factors of procedural unconscionability may apply, right? So this is what I mentioned earlier, the fact that there's some overlap between these two categories insofar as it concerns unconscionability in general. Although fairness is typically a function of the contract negotiations, the way things play out later can help determine whether a contractual provision is unfair ultimately, right? So fairness is a component, but also the outcomes of the contract do matter. Substantive unconscionability, in terms of Lilly's argument, it's important to note, sort of how this played out sequentially. Plaintiff pointed to a previous Oregon case. So Lilly looked at a case where a sales contract was considered unconscionable under the Uniform Commercial Code. And remember, we talked about that earlier as not really being applicable. Under the contract, knowledge and ability to avoid the harm caused by a change in a manufacturing process was a defendant's responsibility, and the parties did not expressly and consciously allocate a risk to the plaintiff in that contract, right? So that was the terms of that agreement. And Lilly is saying, well, look, it's the same thing here. Clearspan is seeking to enforce this waiver when only Clearspan had the power to prevent and avoid consequential damages that would result in the breach. They were the only ones that had any ability to manipulate the circumstances that would affect that, right? Which is what Lilly is arguing, and they're saying that that's what makes this unfair. They're saying it was Clearspan's job to fix the issues with the greenhouses that would have resulted in the lost profits, and in fact did. So disclaiming them, meaning vacating the option to pursue consequential damages, basically just nullifies Clearspan's responsibility to do that, right? Because they're saying that Clearspan put this in here intentionally so that they didn't have to fix any issues with the greenhouse, because by doing so, they're protecting themselves from being responsible for anything but the greenhouse itself. So the only one to benefit here is Clearspan, right? Is essentially what Lilly is saying. And Lilly is further arguing that by doing that, it's unconscionable. It's not fair of them to have put that there because, yes, it sounds bilateral. It sounds like, yes, we're both agreeing to waive consequential damages, but Clearspan is only the only party that's really benefiting from this in the practical world in which this contract took place and the circumstances that it surrounds. So the court, in analyzing the issue of substantive unconscionability, they look at the case was a sale of goods case, and it's again the case that Lilly brought up as an analogy, right, earlier, was a sale of goods case, which is why it was governed by the UCC. And again, as we discussed earlier, for reasons of the fact that this is a construction agreement and a lease agreement, this is not governed by the UCC, as the court found. In that older case, the one that Lilly was trying to use as an analogy to get what they wanted out of it, the victim of the breach had no way of knowing of the defect and was forced to breach contracts with its customers because of the failure of the defendant. So there was a lack of notice about this. But the court says, look, case is different. The Lilly case is different because Clearspan's failure to make the repairs did not go undetected by Lilly and did not cause Lilly to breach a contract with any third parties. In other words, it's not like they had orders for cannabis with others that they couldn't sell or deliver upon because of Clearspan's inability to keep the greenhouse operational, right? So it's not really the same facts, and therefore the precedent that that Lilly's arguing for here doesn't apply. As such, the court ruled that Lilly had failed to meet its burden of proof, demonstrating that the consequential damages waiver in the construction contract would contravene public policy, right? So in other words, they can't show that this is in violation of public policy, that there's an unconscionability here that would require the court to step in and impose, some nullification of the contractual terms, right? Because that's essentially what Lilly's arguing for. They want the court to reconstrue what the contract should say instead of what it actually said, right? So getting to the failure of essential purpose. So Lilly made another argument sort of parallel to this, that the remedies available to them fail in their intended design, right? Their essential purpose, which was the ability to profit from the production and sale of cannabis, right? So that's what this is all about, right? That's what this was for, is what Lily's saying, is the whole purpose of us buying a greenhouse was not to have a greenhouse on our property so that we can look at it and take pictures of it and say, oh, what a nice greenhouse. The whole intent and what was known, right, was that the purpose of this was to grow cannabis for a for-profit business, right, which is what they were in. And that to take that away from us as a remedy to recover against Clearspan nullifies the essential purpose of the purchase of the greenhouse in the first place, is what they're saying. right? So whether a consequential damages waiver remains enforceable, speaking to, again, restatement of contracts and past precedent, when a limited remedy fails to achieve its essential purpose is, again, another case-by-case analysis. So a lot of these depend on just the different circumstances, because as we've seen already, there are cases that Lilly has attempted to bring forward, UCC cases that just don't apply, right? So there's a lot of analysis here. And if they're not apples to apples, they're not going to fly in terms of being persuasive with the court. The essential purpose rule is a statute under the Oregon enactment of the UCC, right? So the state level acknowledgement of the Uniform Commercial Code. So again, as we've talked about repeatedly already, the first issue with this argument is that this is not a sale of goods contract, so UCC doesn't apply. So that doesn't hold much water to begin with. But the court did want to look at this more closely, right? So they said, let's analyze this on an assumption that there could be some merit to the argument, notwithstanding the UCC implications. So the court said that even though consequential damages are disclaimed, right, Lilly still has all other possible remedies that would normally apply, right? So what they're saying here is that, okay, even if you are precluded from looking at consequential damages, you have other ways of recovering from Clearspan. That's not the only means by which you could pursue remedies here, right? So being foreclosed from lost profits doesn't mean you can't still get the benefit of your bargain for the greenhouse. So, one way to do that would have been to make the repairs to the greenhouse so that you could continue operations yourself, right? That was an option available to Lilly. They could have done the repairs so that they could continue to produce cannabis and then sued after the fact to recover the cost of those repairs. And again, as we talked about earlier, here's that term incidental damages, right? Things that are incidental to that process. You could have also asked for replacement of the needed greenhouse, right? So that's a component because you did, in fact, agree to purchase a greenhouse that was never delivered upon, insofar as it was a greenhouse of integrity that would stand up to the weather and not have problems that would disrupt business. So that's an option that's still available for you, even with the foreclosure on lost profits. Even now, you could sue, meaning you, Lilly, could sue, and you are suing for the cost of the repairs, right? So they've asked for that, and they're pursuing that, right? So that shows that this is not the only remedy. It's just one form of a remedy that was foreclosed upon by the terms of the agreement. So lost profits are not the only way to recover, right? Now we get into the issue of whether the lost profits that Lilly is alleging, again, that $5.4 million amount, is justifiable. I mean, assuming we can even get over the hurdle of the issue of the limited liability waiver in the contract, the question is it even fair to take on its face the $5.4 million figure as authentic, right, as sincere and reflective of actual loss? So this brings up what we call the reasonable certainty rule, right, which is that we have to have reasonable certainty with respect to the damage estimate. So this goes all the way back to Hadley v. Baxendale, which, if you look it up, it's a famous case from England relating to a drive shaft for a mill that had failed with respect to repairs to the shaft that were intended to be made. And there was a question as to whether or not the company making the repairs to the drive shaft knew about the nature of the implications of the drive shaft to the revenues of the mill, right, of the people that were running the mill, and what that meant in terms of lost profits for the time that it was in repair. Because there was a company that was transporting the drive shaft from the mill to the repair shop and back, and that company had delayed the actual transport, which delayed the repair, which delayed the recovery of the mill. And then there was a suit that followed therefrom for damages related to lost profits, right, because the mill couldn't run while the drive shaft was absent. And so that's the underlying precedent, but this goes all the way back again to the 1800s. So the point and the rule that stems from this is that your consequential damages, if you're going to allege that as fair game to pursue, they have to be proven with reasonable certainty. You have to be able to show. You can't just throw out a number that you think is reasonable just because you pulled it out of your head, right? I mean, it has to be based on something more than that. So looking again to the restatement of contracts, what does it say? It says damages are recoverable for losses caused or for profits and other gains prevented by the breach only to the extent that the evidence affords a sufficient basis for estimating their amount in money with reasonable certainty, right? So the question is, was the figure that Lilly was relying upon one in which we can rely upon with reasonable certainty? In other words, where did they come up with it, right? Because where the evidence does not afford a sufficient basis for a direct estimation of profits, but the breach is one that prevents the use an operation of property from which profits would have been made. There's another remedy, which is damages may be measured by the rental value of the property or by interest on the value of the property, right? So if you can't establish that there's a number with reasonable certainty for profits lost, there's another way of calculating that. There's an alternative. But this, for obvious reasons, would not be as attractive to Lilly, because Lilly's not really interested in the rental value of the property or the greenhouse, right? Because that's not going to be nearly as much as what they were estimating or alleging that their cannabis profits would have been, right? Given this recent legalization and the interest that people have in buying these products. So lost profits can be proved in a number of ways. With reasonable certainty, bypass profits were expert testimony as to profit projections based on the industry and the ability of the plaintiff to conduct business in the industry. So you can take expert testimony to establish what this should be, right? There's a number of ways of looking at, establishing what that profit figure should be and why it's credible. The profits must be net profits and not just gross products, right? So you can't sue for something that still accounts for costs that you would have had to pay anyway. You can only look at your net profits of what you would have had left over if you had completed, that sale, that production, whatever it is, right? Which only makes sense. Reasonable certainty doesn't have to mean absolute certainty, right? It would not be fair to say you have to tell us the exact figure down to the penny of what you would have been able to sell had you had been able to produce, X amount of pounds of cannabis product or what have you from your greenhouses. So at the end of the day, there just has to be some evidence that allows a reasonable jury to project with reasonable certainty that the level of profit would have been likely to occur, right? They have to be able to base their interpretation on something that is reliable, right? And so this is where we get into the case by which Lilly is asserting that their figure is appropriate. So unfortunately, Lilly is a new company, again, as are most of these companies with respect to legalized cannabis, because this is a very recent trend. They had no history, right, to bring, and they did not even produce an independent expert that could project profits. And that's not surprising, coming from my own background as an expert witness and as a consultant, because you don't have any history in the industry to show what this ought to be worth in the United States, period, because there's just nothing, there's no precedent for it. It's never happened before. So a lot of this is speculative, right? That being said, Lilly did detail a business plan that could conceivably lead to the types of profits that they're suggesting would have occurred, but it didn't have any experience growing marijuana. It didn't have a formal business plan for their operations, and it had just a couple of prospective clients. So it really hadn't hashed this thing out with any kind of certainty or confidence, which would have given the weight or the necessary credibility behind the claim that, hey, we can say with reasonable certainty, right? That standard that this is going to be the expectation of profits in that respect. So it did hire consultants, but they didn't have any experience growing cannabis on a commercial scale, and they were quickly replaced in the business. So there was a lot of turnover, as is common with new startup companies. But with respect to that, this is something that had a pretty profound effect on the argument that Lilly was putting forth with respect to lost profits, because they didn't have a very large authority or weight around the idea that there was reasonable certainty in the analysis of their $5.4 million revenue figure, that's something that, the jury should find to be a reasonably reliable number for what they might have lost from the production of cannabis in this respect. So on that subject, Lilly's projections for lost profits came down to the price they could get for their goods minus the cost of goods sold. But they did not clearly establish that it could run its business to its most efficient extent, right? So they hadn't even gotten far enough to show that was something reasonable insofar as cost of goods sold, panning out over some long-term production of the product to say this is what we typically saw as a net profit margin, and then we could multiply it by the number of, tons of this product that we would produce, and then assuming that we sell X percentage of that in the actual market at what fair market value would yield. There was just too much speculation in this respect. So the court found that it had submitted too little evidence, even to submit the case to a jury on a theory of lost profits. So that was a problem that ultimately was fatal to the Lilly claim of lost profits as a figure, even assuming you could get past the limited liability waiver issues and get to the issue of the claim of the figure and how that relates to the overall equation of whether or not it could be relied upon. So the final element here that the court wrestled with for the circumstances of looking at this case was that sua sponte issue we talked about earlier of the illegality of selling cannabis, and whether or not that raised an issue that would preclude the court from even being able to address the lost profits claim, because they could still address a claim about a greenhouse purchase that did not pan out in terms of the quality of the product or the integrity of the structure, right? None of that necessarily implies an inherent use for some illegal purpose, right? So if there's just a sale of a greenhouse or a lease or a construction agreement for a greenhouse, that doesn't necessarily have to implicate these Controlled Substances Act regulations that would raise concerns for the court. But it's the issue related to the lost profits for a product that is illegal for sale under federal law that the court had concerns about. So again, the court raised this issue of whether a federal court, this is not a state court, this is a federal court, so there's an interesting position here, can award a party lost profits generated from the sale of marijuana. Again, cannabis is a Scheduled I controlled substances under federal law. Manufacturing, processing, or distributing of the product for recreational purposes is a federal crime, regardless of the state law on the subject. A federal district court may not enforce a contract if enforcing the contract would require a party to engage in conduct that is unlawful under federal statutes, right? So a contract for anything that is unlawful is unenforceable regardless of the context. But again, this is specifically speaking to the federal nature of the fact you have a federal law that prohibits certain contact or conduct, and you have a contract, part of which the remedies being sought over is for illegal conduct under federal law. So under Oregon law, it is an affirmative defense to a breach of contract action that enforcing the contract would violate federal law, right? So that's a defense to any kind of breach of contract action in Oregon in addition to, right? So this further doesn't help the case, unfortunately, for Lilly, right? So the key issue here is that under Oregon state law, as we discussed earlier, distribution of marijuana is legal, right? So it had been legalized under state law. The federal court in this case was sitting in diversity jurisdiction, which is important because they weren't wrestling with a federal question. So it was the kind of jurisdiction which gives federal courts the ability to hear claims where parties are from different states, right? So that's the only reason they were in federal court, was diversity jurisdiction and not a federal question, which means that normally they would operate with the state law that would control, depending on what the contract stipulated in that question, which means they could adopt a state law view of this, but they're still a federal court, which is the difficult part. And so nevertheless, a string of cases in federal courts refused to enforce contracts that violated federal marijuana laws. So this is a precedent that had been set. In the briefing process, Lilly pointed out a case in the same district that allowed a lost profits claim derived from a cannabis growing business because it was legal under state law. So, again, they had identified a case that they hoped would be an acceptable analogy and something persuasive because they allowed a lost profits claim from a cannabis growing business. So there appeared to be something they could, push as like for like. But nonetheless, we look at the application here. The court found that awarding the plaintiff damages for lost profits would require that court to compel defendants to violate the Controlled Substances Act, right? It would essentially force the Clearspan company to pay them for the sale of illegal goods under that lost profits claim, which would violate federal law, right? So the Controlled Substances Act precludes this court from awarding plaintiff lost profits and provides an independent basis to dismiss the lost profits claim. So even if we didn't have the limited liability issues and all of the other, the damage estimates issues, we still find another independent reason not to do this, is what the court's saying. So in other words, even if legal under state law, they're not going to entertain this in federal court because it's still illegal under federal law. So concluding, the court, for all of the reasons we've discussed, granted the summary judgment to Clearspan, ruling that it is entitled to summary judgment and that Lilly is not entitled to their lost profits claim for any one of the three reasons that we discussed. One, the fact that there's a limited liability provision in the contract. 2, the lost profits themselves were too speculative. There wasn't reasonable certainty as to the number. And 3, it was illegal under federal law to sell cannabis, so the court couldn't even entertain that notion. So it's important to note that this doesn't preclude Lilly from pursuing the other claims of their breach of contract with respect to the quality of the greenhouse and the damages that they incurred from that, the repairs that were needed, or even replacement costs, depending on how damaged it was or how recoverable it was. All that's still fair game. The only question that this court was wrestling with and ultimately shutting down was the question of, can Lilly recover lost profits from cannabis resulting from this greenhouse failure? And the answer was conclusively no. So with that being said, thank you for listening, and we'll see you next time for another great video. Take care, everyone.